use time, because we're preceding each board meeting with a development session. And rather than having to take, a couple of hours, half a day or a whole day, they're snippets of information, but they're fundamental to understanding the safeguarding agenda. It's what the core elements of our safeguarding agenda are about. So I don't want to do introductions because they're quick sessions. We want it to be snappy. I just wanted to remind you that Claire sent out information on the further development sessions in March and May. We've got another 3 in July, September, November. And if there are any particular topics or subjects you think would be helpful or relevant, if you can contact Claire, because we're looking to complete the programme for the rest of the year. So without any ado, I'm going to just hand straight over to Claire to take us through the slides. Thank you, Claire.
Thanks so much, Vida. That's really helpful. Phil, you've just popped in the chat to ask if it's okay if the slides can be shared. That's absolutely fine. I will send out the PowerPoints. I'm also recording the session, and I will send that out as a link as well. So hopefully that's helpful. As Vida said, this is the first development session. We're going to focus on section 42 of the Care Act, and the first 3 of the development sessions are focused on the 3 relevant sections of the Care Act, sections 42, 43 and 44. And I suppose it's just important, to start off that the care and support statutory guidance, which is linked to the Care Act, is clear that the safeguarding duties within the Care Act have got legal effect in relation to organisations other than the local authority. So some of the, I guess the phraseology puts a lot of emphasis on local authority duties, but it is so important that all partners are familiar with the legislation and its implications. So I thought I would start off with what the legislative text itself says within section 42, and it's divided into 2 parts, part 1 and part 2, and then there are subsections to that. And the legal text is really important because it does give us a number of definitions and criteria that we work to in safeguarding adults. So the first one is the adult at risk definition, which is effectively the first part 1 of section 42. And that's who we are concerned with safeguarding. So it's who we're concerned with as a Safeguarding Adults Board in terms of safeguarding, and it's who our Safeguarding Adults policies and procedures apply to. So it's adults in our area who've got needs for care and support, and who are experiencing or at risk of abuse or neglect, and as a result of those needs, unable to protect themselves against the abuse or neglect. And I think a couple of important things to take from that, we're not talking about all adults in Newcastle. It's specifically those who've got needs for care and support. And I think another thing to point out is there's no significant harm threshold in that definition, the same as which there is in child protection. So a couple of important things I think to take from that. It also gives us the Safeguarding Adults Concern criteria, which is parts A and B of the adult at risk definition, and that is what referrers should be considering and using when they make safeguarding adult referrals. Just admit Simon. It also gives us the Safeguarding Adults Inquiry definition. Oops, sorry, I'll just go back to that. And that is effectively the same criteria as the adult at risk definition, and that's all 3 parts of that first section. So that's the criteria when a section 42 inquiry is recorded, and when we're looking at things like data that we report on safeguarding adults concerns and section 42 inquiries, that is what we're using to determine when that criteria has been met and looking at volumes. And then finally, that second part 2, indicates the local authority duty for making or causing inquiries to be made. The statutory guidance gives us a bit more information on the legislative text and what is meant by that, so the further details on how it is expected that the law will be implemented. And Chapter 14 of the statutory guidance is specifically concerned with the safeguarding aspects. And I've got a link on the last slide to the statutory guidance, but you can jump straight to Chapter 14, which is the safeguarding chapter. So the statutory guidance says that safeguarding duties apply equally to those adults with care and support needs, regardless of whether those needs are being met or not. So somebody doesn't necessarily have to have a care service in place or their needs being met, the safeguarding duties still apply. The person doesn't have to lack mental capacity. The person can have capacity, and we would safeguard them the same. And it doesn't matter where the person is living or where they currently are. They could be in a hospital, a care home, at home, in the community. The specific references to transition from childhood to adulthood in the statutory guidance, and it's specific really in terms of even if the child continues to have involvement from children's and young people's services, once that child turns 18, the safeguarding duties move to adult arrangements, and that's why we've got things like our safeguarding transition protocol in place to hopefully make sure that that's a smooth transition when that happens. The statutory guidance lists the different abuse types. So in addition, I suppose, to the four most common of physical, sexual, neglect and emotional, there are a further 6 listed within the statutory guidance. So that includes self-neglect, domestic abuse, modern slavery, financial, organisational and discriminatory. At this point, I'll point out that self-harm and suicidal intent is not an abuse type covered by safeguarding duties. The guidance says that local authorities may choose to undertake safeguarding inquiries for people where there is not a Section 42 inquiry duty. So if the local authority believes it is proportionate to do so and will enable the local authority to promote the person's well-being and support a preventative agenda, an inquiry can be undertaken. So if people have seen our performance information, we often have other inquiries listed and numbered, so that would be those circumstances where the local authority is undertaking inquiries but the full Section 42 criteria isn't met. The guidance says that local authorities must cooperate with each of their relevant partners, and those partners must also cooperate with the local authority, and there is a specific section within the Care Act around cooperation. And I guess that's what we do as a safeguarding partnership. We hopefully work together to safeguard adults at risk. It says that the inquiry should reflect the 6 key principles of adult safeguarding, and they're listed on the bottom of the slide there. And what happens as a result of an inquiry should reflect the adult's wishes wherever possible, or their representative or advocate where they're not able to state those themselves. Inquiries should be proportionate to the presenting level of risk. So when we say that there isn't a significant harm threshold within the legislation, that still doesn't mean to say that we shouldn't be considering that principle of proportionality in terms of what the presenting risk or harm is. So in terms of Section 42, the when, the how, the why, the who, Section 42 inquiries must be undertaken when the Section 42 definition is met, and it's the local authority duty to lead and coordinate those inquiries, but it may require others to undertake them, and that happens a lot in safeguarding inquiries. Often it is the local authority chairing meetings or leading inquiries, but they're asking other agencies to do things. And one of the things I often say is that the Care Act didn't give any additional powers to safeguard adults other than that duty to undertake inquiries. And really the success of a Section 42 inquiry is really reliant on the contributions made by all agencies. The Care Act goes on to say that it's the local authority responsibility to assure itself that an inquiry satisfies its duty. And if the local authority asks somebody else to make inquiries, it could potentially challenge that organisation if it considers that the process or outcome is unsatisfactory. I think it's fair to say that every Section 42 inquiry will be different. The statutory guidance does not require a particular process to be followed. In fact, I think the one sentence that I often remember is that it states an inquiry could range from a conversation with the adult or their representative, right through to a much more formal multi-agency plan or course of action. Ultimately, the purpose of an inquiry is to decide whether or not the local authority or another organisation or person should do something to help and protect the adult, and the guidance lists the objectives of an inquiry as being to establish the facts, understand what the adult or their representative wants to happen, assess their need for protection, support and redress, make decisions about actions against the person causing harm, and enable the adult to achieve resolution and recovery. And then, as part of Section 42 inquiries, a safeguarding adults plan, sometimes referred to as a protection plan, should be developed and adjusted. And then at the end of an inquiry, some of those actions might then continue as part of that person's day-to-day care or treatment plan, for example, and the safeguarding inquiry is closed. So then coming down to a local level and how we've translated that into our multi-agency policies and procedures. Since the advent of the Care Act, we've taken a staged approach to safeguarding to provide that structure and framework to how we undertake safeguarding work. So we've got stage 1, which is the referral and triage. That's determining whether the referral that's made to the local authority meets the safeguarding concern criteria. Then we've got stage 2, when the concern criteria is met, initial inquiries are undertaken to gather more information from people and agencies involved to determine whether more formal inquiries or investigations are required. Then we've got stage 3, which is the strategy and investigation stage. That can be held as either a discussion or a meeting, and that sets what's effectively, I suppose, like the terms of reference for a more formal inquiry, what investigations or assessments need to be done and by whom. If it's a relatively straightforward concern, it might be that there's a discussion with the agency responsible for doing the investigation and they are just tasked with that and then asked to report back. And then we've got stage 4, the protection plan review stage. This is generally for cases where risks are high and are complex. At this stage, all information is known about the risks, although they potentially could change. And a safeguarding adults plan has been developed and in place, but it requires some scrutiny and oversight monitoring from the safeguarding adults inquiry, from the group that's undertaking that. And at this stage, core groups can be established to monitor that plan and risks on a more regular basis. So you potentially could have a protection plan meeting and then not have another review for 6 months potentially, but you'd establish core groups to look at the plan on a more regular basis. The safeguarding inquiry can end any of those stages. Usually it's when risks are managed as far as possible and it's a multi-agency decision that inquiry ends. There isn't a requirement to have a multi-agency meeting other than at the stage 4. We stress throughout our policies and procedures that the involvement of the adult or their representatives, so the Making Safeguarding Personal approach, is emphasised at all stages from referral right through to contributions at meetings, whether that's attendance at meetings or providing information into meetings. And then I suppose within the policies and procedures and associated practice guidance, we include lots of different tools or guidance that support implementation of the Section 42 duties. So things like our multi-agency referral form assist with making sure our inquiries are person-centred, person-led. Our risk threshold tool assists with taking a proportionate approach. We've got things like our investigation report template, which agencies can use to submit information if they're requested to undertake an investigation. And as I've mentioned before, things like our transition protocol, which explicitly states what should happen when a child's moving to adulthood and there are safeguarding concerns. So moving on to what our local performance information tells us about implementation of Section 42 in Newcastle. I think most people on this call will know that we've got high numbers of safeguarding concerns and safeguarding adult inquiries per head of population in Newcastle compared to the rest of England. Our performance information shows that nearly half of all of our safeguarding adult referrals do not meet the criteria for a safeguarding concern, and attendance at safeguarding adult meetings has been highlighted as an issue in the previous year, and that is something that is being looked at by our Improving Practice Committee. And I suppose lastly from me, before we'll move on to if anybody's got any questions or comments, is I suppose from in your strategic roles, I've just prompted some questions for people to think about, not necessarily today, but to go away and maybe think about. Does your training reflect the legislation, statutory guidance, and local policies and procedures? Do you have policies and procedures which reflect your organisation or profession's role in Section 42 duties? Do you understand the extent to which your organisation or team is involved in Section 42 duties? How often you might be asked to provide information at a stage 2, how often you might be asked to attend safeguarding meetings, how able your organisation is to attend those meetings that you're invited to. And I suppose that follows on into the next one, which is about whether your organisation has the resources to meet those Section 42 duties. And then finally, do your systems and processes support the effective coordination of and contribution to Section 42 inquiries? And the last slide is just the links to some of the further information around Section 42. So starting off with that legislative text, then the statutory guidance, that chapter 14. On the back of, I suppose, the discrepancies around some of the data capture around safeguarding concerns and Section 42 inquiries, the LGA and ADAS did publish some further guidance on understanding what constitutes a concern, and also the making decisions on the duty to carry out safeguarding adults inquiries. So that really goes into a bit more depth around those two things. And then finally, our local policies and procedures. I am more than happy to take any questions or comments that anybody might have in relation to that. I appreciate it is